So welcome everyone to this side event, virtual side event to the 49th regular session of the UN Human Rights Council. This is a non-official side event, I'm minded to say that. Currently we cannot hold physical side event at the Palais des Nations, so we are resorting to Zoom, but that's also a way to actually reach both to the delegations and to the general public as such. So we're happy to see that we have lawyers, we have human rights defenders, but also delegates from the UN in Geneva. This side event is organized by the International Commission of Jurists, Amnesty International, Article 19, Human Rights Watch, in cooperation with the mandate of the UN Special Rapporteur on counterterrorism and human rights. I will try to be as brief as possible because really we have a very short time. One motion of order, a couple of motions of order, a couple of rules, house rules. There are 5 panelists, as you can see, which have been introduced to you. If you have questions or answers, there is a Q&A written section you can write there, and we will try to address after the presentations the questions. If you are from a state delegation, I would advise to identify yourself by changing your name. And if at a certain moment you, at the end of the presentation, you wish to take the floor to reply to certain remarks, please write so in the chat, and I can also promote you to panelists if you want to do it in a video way. Of course, we're going to name countries and situations, but this is also particularly a thematic side event. So we're going to go through practices of different countries. That said, explained a bit the rules. This event title, which is Renditions and Their Legacy of Impunity, is a 20 years recap of what's happened in 20 years. 20 years ago, the then government of the United States began a program of extraordinary renditions, as they're called, that involved capture, abduction, torture, arbitrary detention. You're going to hear all the violations of several people across the world with complicity of different states. That program has been officially closed in 2008. However, the impact and the legacy, we feel it to today. Civil society that back then said that we needed accountability to avoid things to repeat. And the event of today is to explain to also people who weren't there, or to people who may have other priorities and in the meantime they have forgot about it, that actually what's happened 20 years ago is still well alive with us today and is influencing practices and human rights violations today. So without further ado, I will introduce you to our panelists, our distinguished panelists. I'm really proud to have this panel. Frankly, I'm the youngster and the humble of this group. We will have first to speak the president of the International Commission of Jurists, Professor Robert Goldman, who was the independent expert on counterterrorism and human rights, but also commissioner of the Inter-American Commission on Human Rights that worked on the report on terrorism and human rights back in those years when it was produced. We have Julia Hall, who's I think one of the most eminent experts I know on counterterrorism and human rights and on these kind of issues. In the last 20 years, she went across the world to really ensure accountability for violations of human rights done by the CIA rendition program. We have Helen Duffy, the Director of Rights in Practice, and one of the most skilled lawyers, human rights lawyers you can find in these days across the world, who's been representing actually victims of these programs in front of international courts. We will hear also about her experience. And last but definitely not the least, Fionnuala Niolin, the UN Special Rapporteur on Counterterrorism and Human Rights, who is going to present also next week a report at the UN Human Rights Council on this topic, but has also been speaking for many, many years about these issues and the legacy for them. So I'm very pleased to have this panel, and without further ado, I will give the floor first of all to Professor Goldman to start us up a bit about the CIA program, where it does come from, and the evaluations that it entailed. Professor Goldman, Bob, the floor is yours.
Thank you very much, Max, and it's a pleasure to participate on this in this side event, and I want to thank all of the organizers for this important initiative. As Max has stated, the policy of extraordinary rendition, secret detention, black sites, and the like was the result of policies put in place by the Bush administration in the wake of the 9/11 attacks. As Max indicated, 20 years later, we are looking at the bitter legacy of that policy, how other states were complicit in the illicit practice of extraordinary rendition, and how it's given license and so forth to other states to engage in similar illicit behavior, and the absolute and utter lack of accountability and so forth that we have today for these violations. I think it's important to note that after the 9/11 attacks, the Security Council passed a resolution in which it mandated that states' counterterrorism policies had to conform to international human rights law, and where relevant, international humanitarian law and refugee law. And quite frankly, it's hard to envision a practice that is so exquisitely antithetical to the basic notions of human rights and the rule of law than extraordinary rendition. Extraordinary renditions really represent and entail multiple serious violations of human rights law. They include enforced disappearances, arbitrary, prolonged, and incommunicado detention, torture and other ill treatment, denial of a fair trial, essential judicial guarantees, and at times it has actually resulted in death. And also, one cannot discount the serious violations of the rights of the family members of persons who have been subjected to this practice. Now, enforced disappearances and so forth, including issues of extraordinary rendition, have been items on the agenda of the International Commission of Jurists for many, many years. And let me say that it has been a long-standing concern to me personally in my professional work. During my 8 years as a member of the Inter-American Human Rights Commission, I was the Commission's country rapporteur on Argentina, which meant that I frequently visited that country and met with the mothers and the grandmothers of the Plaza de Mayo, as well as relatives of others who had disappeared in that country. And I came to see firsthand the terrible effects, the anguish, the uncertainty that these people felt, not knowing the fate of their loved ones. And I also was able to see the trauma that enforced disappearances have had on Argentina to this day. In 2005, when I was the old UN Human Rights Commission's independent expert on terrorism and human rights, the practice of renditions was just beginning. We did not know the full extent of it. But in my report to the commission, I expressed very deep concern over this US-led practice, how it was undermining the prohibition against torture, the notion of non-refoulement, and how it evaded necessary judicial oversight and legal safeguards for the persons concerned. Subsequently, in 2007, when I was a member of the EJP panel on terrorism, counterterrorism, and human rights, which was an ICJ-sponsored initiative, I traveled with the then president of the International Commission of Jurists, Justice Arthur Chaskelson, to our hearings in Canada. And at those hearings, we were able to meet privately for a long period of time with Maher Arad and his family, where we were again able to firsthand learn of the terrible effects of his rendition at the hands of the United States to Syria, where he was tortured and eventually was returned to Canada. I should mention that while virtual impunity exists with respect to the perpetrators of these crimes, Canada is one of the bright spots in that there was a public investigation, a public apology, changes in practices to ensure non-repetition, and Mr. Arar was able to at least get some compensation. Notably, and in contrast, all of his attempts to secure a modicum of redress in US courts have failed as a result of the use of state secrecy, privilege, and the like. Let me conclude by saying this. I think that we need to label these things what they really are. In my judgment, a policy of extraordinary rendition, which occurs in the context of armed conflict, whether international or non-international, should be considered a war crime. And to the extent that the practice occurs outside of recognized situation of armed conflict, if systematic in nature, it should, just like enforced disappearances, be regarded as a crime against humanity, and as such, subject to prosecution by all states on the theory of universal jurisdiction. Well, I look forward to hearing from the other panelists, and thank you very much.
Thank you very much. Thank you very much, Professor Goldman, for this intervention. I will give immediately the floor to the second panelist, but I would recommend, if it's possible, Professor Goldman, to switch off the microphone, because otherwise you will go as panelist. The next one speaker is going to be Julia Hall from Amnesty International, that will let us know about all the thread, actually, of complicity that there has been in the CIA rendition program, and how difficult it is actually to get accountability for this violation. Julia, the floor is yours.
Thanks very much, Massimo. Thank you, Professor Goldman, and to all the organizations who have co-sponsored this event, Human Rights Watch, Article 19. Obviously, a special note of gratitude to the Special Rapporteur for continuing to carry the torch on this essential accountability work, and a very happy International Women's Day to all the women on the panel. As you know, Amnesty International has been doing this work for 2 decades. Research, advocacy, campaigning. It is very distressing to be sitting here 2 decades later with so little accountability on the US side, and some but very little in the grand scheme of things on the European side. So my job today is to talk about complicity of US allies and various countries with the United States in this rendition and secret detention operation. And I'd like to frame my comments around three very short stories. It's very hard to compress a couple decades of work into 7 minutes, but I think these stories are reflective of various points along these last couple of decades that were very meaningful to us at Amnesty and to me personally. And sometimes a story is a very useful tool to convey a message. So story number one began on 19 December 2001, which is the first time that we, I think in the international community, had really heard of a formal extraordinary rendition. 2 Egyptian men were scooped off the street in Stockholm, Sweden. Their clothes were stripped of them. They were drugged, shackled, and transported from Sweden to Egypt, where they were imprisoned and tortured. Amnesty International's urgent action on that day, typed on a hand typewriter, I might add, referred to something called diplomatic assurances. In other words, the Swedish government had justified this transfer in collaboration with the Egyptian security forces and the United States government because they had received written guarantees that the men would not be harmed if returned. The special rapporteur has noted in her report the emergence of so-called diplomatic assurances against torture, their inherent unreliability from governments where torture is endemic. It was a shocking thing, actually, to see Sweden transfer these 2 men back to a place where they were in fact tortured. And it gave rise to a cottage industry of master's degree students working on the issue of diplomatic assurances. It is also one of the issues that move from the margin to the center in terms of state practice, because we see states all over Europe, North Africa, Russia, Central Asia, now routinely using diplomatic assurances to justify transfers to risk of torture. Little did we know then that Sweden would become only one of dozens of points in what the Council of Europe in 2006 called a spider web of extraordinary rendition flights that implicated, at that time, between 30 and 40 countries. And that is an iconic map that I wish I could have posted into the chat, but I'm a little technologically challenged today. The map is striking for the number of flights all across Europe, North Africa, into Central Asia, and as far flung as Thailand. And eventually we learned also Diego Garcia. So the US had a lot of help in this operation. In all, over 50 countries were complicit, some more deeply than others, but it's a fact that without the support, both logistically and materially, of these countries, the breadth and scope of the rendition and secret detention program and the attendant horrible abuses that Professor Goldman just detailed would not have happened. The US could not have achieved this without these governments. I'd like to tip my hat to the Open Society Justice Initiative's report that was released in 2013 called Globalizing Torture, which really documented and upped the number of those countries to 54, in fact. Between 2004 and 2014, while there was virtually no accountability on the US side for these practices, we saw an upsurge of activity on the European side. By 2014, the European Court of Human Rights had ruled against Macedonia and Poland for their complicity in enforced disappearance and torture. We know now that Poland hosted a secret detention site. The Committee Against Torture and the UN Human Rights Committee actually found against Sweden for those renditions of the 2 Egyptians from Stockholm back to Egypt. And so there was a dynamism on the European side that we weren't seeing on the US side. So story number 2 was an opportunity for me and Amnesty International to talk about all that dynamism on the European side. And it begins in early 2015 when Amnesty USA asked me to go to Washington and to brief the Senate Select Committee on Intelligence staff that had just produced the 6,000-page Senate torture report. They wanted to know what was happening in Europe. And they gave us 20 minutes, and about an hour and 20 minutes later, they were still very interested to hear about all of the activity in the European Court of Human Rights, by then in the inter-American system at UN level. They really were so focused on the torture and ill treatment that occurred in secret detention at the hands of the United States government that they hadn't been able to keep abreast of what was happening in Europe. Now, you all know that the Senate Select Committee on Intelligence report was 6,000 pages. It remains classified. It is a recommendation of everyone who's involved in this work that it be declassified and made public to the extent that that's possible. What was interesting about the report was, even though we knew that secret detention sites by then, we knew they existed in Europe, in Poland, Lithuania, in Romania, in Thailand, etc. None of those countries were named in the report. They were given color codings. So Lithuania was violet, and Poland was blue, and Romania was black, and it all seemed quite poetic until you got into the text of that report, where we learned what happened in those secret detention sites. Abuses so brutal and appalling that it really defies words even to date, as Professor Goldman had noted. One of the Senate Select Committee on Intelligence staff members was effusive in their thanks for understanding what was happening on the European side, and said, we've heard very little about what's happening in Europe. I give all credit to people like Helen Duffy for making that a reality. Story 3, and this I will conclude with story 3, is very recent actually, was the fact that I went to Guantanamo Bay in January of 2020. And I traveled there. I swore I would never go back because it's such a black hole for a lawyer to sit in. But I went because James Mitchell and John Jessen were giving testimony in the military commissions in the pretrial hearings. And it was really important in our work for us to sit and listen to the designers of the enhanced interrogation program talk about their role in designing, implementing, and in fact executing those techniques. And they did execute some of those techniques in the secret sites that we're talking about. According to John Mitchell, he traveled to several sites overseas to make sure that enhanced interrogation techniques like waterboarding, brutal beatings, isolation in closed boxes, etc., were fully executed by various members of various agencies of the United States government. It was striking to sit at Guantanamo and listen to a person who has tortured people, not only talk about the torture that they inflicted on these men, but also celebrate it. And so it brings me back to the idea of what Professor Goldman has said, and that is that we have to really redouble our efforts to seek accountability for these practices, that individuals who have committed crimes under international law must be held accountable individually, and that states that have been complicit in these practices have to continue to be held accountable. I end with the recommendation of the Special Rapporteur in her report to the governments of Lithuania, Morocco, Poland, Romania, and Thailand to either reopen or establish investigations. Look, these countries know what happened in their countries. They often will say, oh, we have to have the cooperation of the United States government before we can actually come to any conclusions. I would have to say that that is categorically untrue. These countries do know what happened. They have the capacity to investigate and hold perpetrators accountable. And I would like to say that that is going to be the continuing work of Amnesty International and all of those of us on our team who've worked on this for 20 years. If it takes 20 more years, we'll be there. Thanks very much.
Thank you very much, Julia. And yeah, that's, I think, a perfect testimony of all the work that has been done. And I share the feeling that is really discouraging after 20 years to be still talking about this, but that's not a reason not to continue our work. Our next panelist, exactly on this line, Ellen Duffy, another relentless human rights lawyer that hasn't wavered a second to seek for accountability. And they can tell us really even more as a lawyer, what does it mean working with victims of these renditions and try to bring these violations to account. Helen, the floor is all yours.
Thank you, Massimo, very much. It's really a great honour to be part of such an excellent panel, and I'm very grateful to you, to ICJ, Human Rights Watch, Amnesty Article 19 for organising this. And I also just wanted to recognise the really important work in particular of the UN Special Rapporteur on Terrorism and Human Rights, including that very recent report that's been referred to on secret detention. I think part of what is so crucial about what your mandate does and the really important work of civil society is when it focuses on issues that are perhaps politically difficult, disfavored, deprioritized in a sense, but issues which I think we ignore at our peril. And I do think that looking at the practice of rendition and the impunity that surrounds rendition is certainly one of those issues. I think it's crucial that we step back and we reflect on the price of the stark impunity that we see today. I have been asked, though, to say a few words about the case of one of my clients. I have the honour to represent a man called Zain Abidine Mohammed al-Hussein. He was known as Abu Zubaydah. Abu Zubaydah was one of the first so-called high-value detainees who was taken into CIA detention, held at multiple black sites, brutally tortured by the CIA and its contractors, facilitated, as we know, by the complicity that Julia Hall has spoken to of multiple states. He was then transferred on to Guantanamo Bay. I really want to underscore that this month, Abu Zubaydah will have been detained in arbitrary detention for 20 years. So, you know, we've reflected a lot about the war on terror, the 20 years of the war on terror, the implications of that, and we really do need to look at that big picture. But we also just need to focus on the reality of a human life and a human being who has been in arbitrary detention for 20 years. So I'm talking about someone who has never been charged with any crime, who has not had a trial, who has no real prospect as far as we can see of trial, or at the moment of release, though of course we hope that will change. He's never even had the lawfulness of that detention reviewed in habeas proceedings, despite the fact, of course, that the United States Supreme Court decided many, many years ago that all detainees have the right to habeas challenge. His case, in a sense, epitomizes some of the characteristics of the rendition programme and some of the challenges that we face today. And I think this is relevant to reflecting on the legacy. So what I wanted to do is just to flag 5 characteristics, illustrating them by reference very briefly to his case and reflecting on what they mean for the future. Some of this very much goes back to what other speakers have already said. So 5 quick characteristics epitomized by Abu Zubaydah's case. The first is just to recall, I think, the egregious and notorious nature of the crimes, and Bob Goldman has set that out very well for us. We're talking here about very well established crimes under national and international law, where states around the world have jurisdiction, national states where Zubaydah was held and tortured, other states under the principle of universal jurisdiction, international, transnational jurisdiction. We're talking about the most systematic torture, and abundant evidence is now in the public domain of, for example, the fact that our client was subject to systematic torture, including repeated waterboarding, prolonged detention in coffins, beatings, prolonged nudity, humiliation, sexual violence, torture that brought him to the brink of death and required resuscitation. Abundant evidence of egregious, well-established, notorious crimes. The second characteristic is the one that Julia Hall really underscored, which is that these are global crimes. And that is, I think, a remarkable and important aspect of what we're dealing with. We're dealing with crimes of a systematicity that we've perhaps rarely seen, involving this global spider's web of criminal activity around the globe. Third characteristic that Massimo alluded to in his introduction is and why perhaps it's so important to talk about this today. One of the reasons is that the ongoing nature of the violations. And in Zubaydah's case, that's striking, of course, because, you know, he's held in the circumstances I described in Guantanamo. That is a clear and a direct continuation, I would suggest, of the arbitrariness and the cruelty that the extraordinary rendition programme embodied. So the violations of his rights are very much continuing. And in a recent case, for example, that we brought on his behalf before the UN Working Group on Arbitrary Detention, we've argued that in fact this continuing arbitrary detention in a circumstance where an individual has no control for the rest of their life, it's not based on law, it's not based on their culpability, that this also amounts to torture on an ongoing basis, and indeed a violation of the right to life with dignity, to use the words of the UN Human Rights Committee. So we're talking about ongoing violations. Massimo, I believe you'll also talk about the fact that these violations, of course, are violations that we see replicated elsewhere, and therefore they're ongoing in other ways as well. Fourthly, just to underscore the excessive secrecy around this programme and the fact that that secrecy continues to today. I think perhaps emblematic of that secrecy, which has taken many forms and is of course a broader characteristic of counterterrorism and the war on terror, is I think the emblematic decision of the US Supreme Court this week, or in the course of the last week, where the court upheld the blocking of questioning of CIA contractors, to whom Julia Hall has already referred, these contractors that were involved in the design of so-called enhanced interrogation techniques for torture. And the Supreme Court has upheld state secrecy doctrine to preclude them being questioned in the context of a Polish investigation. And the rationale being that what happened to Abu Zubaydah and where it happened, his torture and where that took place, is a state secret. This despite the fact that, for example, the European Court of Human Rights, in cases where I represented Zubaydah along with others, in those cases, the court found that it was beyond reasonable doubt that Zubaydah was held in Poland, for example. But this is just one example, I think, of many, of a very excessive and overreaching approach to state secrecy. And we really do need to ask ourselves, I think, in a world that is so truth challenged and in a counterterrorism context that, of course, epitomizes that, I think, what the implications of this excessive state secrecy has been. And I think there's a real need to address that. We also see it in the lies and misinformation that's been put out about detainees like Abu Zubaydah. You know, the recent hearing in the US Senate, you know, misinformation being restated, even in that context, about who these people are, the supposed worst of the worst and the most dangerous people, yet people who've never had any opportunity, as in our client's case, to defend themselves or to share their truth. So I think we know that truth has been a terrible casualty of war on terror, and I would say that his case really represents that. The US Senate Intelligence Committee report, incredibly important development in illuminating the truth, one of a number around the globe. That report, of course, which made clear that misinformation had been shared about Abu Zubaydah, but many things continued to be repeated about him that were simply not true and not based on evidence. And yet that report, of course, is itself not yet in the public. Fifth, of course, would be impunity itself and the lack of reparation. I think our fifth characteristic that his case really epitomizes is just to shine a light on how stark that impunity has been. We have made progress, lots of things have been done, and I think it's important to recognise that. It's important to recognise the work of many, not only civil society, but human rights bodies around the world, the work of the European Court, the delisting, the UN sanctions ombudsperson who delisted Abu Zubaydah because he's not a member of Al-Qaeda, helping to illuminate, I think, the absurdity of his continuing unlawful detention. Many others, the Inter-American Commission that's been referred to, the work of the UN Human Rights Committee, as well as the Special Rapporteur and others. But the fact is that we still, from the states responsible, when many states have been found to have been responsible for his rendition and torture, we still don't have acknowledgement or apology from any of them. And we have to ask ourselves, why not? This really compounds, I think, the dehumanization at the heart of the programme. Why can people not acknowledge when there's such abundant evidence? And And why can they not apologise and recognise their role? Why is it that not a single person has been held to account and no one has been imprisoned for their role in Abu Zubaydah's torture and the torture of many, many others? As far as I'm aware, it's still the case that the only person who's been imprisoned is the former CIA official who allegedly leaked information. This is an absurd situation. And so to conclude, I mean, what does all this mean? I think it gives us a lot to reflect on. First and foremost, for the human beings whose lives have been essentially discarded. Still 38 people in Guantanamo, like Abu Zubaydah, whose right to life and the whole host of their rights are not being respected. But more broadly, I think, what message does this send? I think there's a very powerful, destructive message that is being sent from the ongoing impunity surrounding the rendition programme. And I think essentially it is that some are above the law and some are below the law. And that, fundamentally challenges, I think, the rule of law and the whole notion of human rights. I think, I'm afraid to say, it fuels the allegations of selectivity that we have heard in recent days and weeks. It undermines the really important work that states and others need to do, that institutions, international institutions, in their efforts to enforce international law in other contexts, where there's been such stark selectivity in the enforcement of the international rule of law around the rendition programme. And although I know it's not always a popular argument, it also does fuel recruitment narratives. And I've seen this just finally in work that I've been doing recently on counterterrorism in Africa, where I've heard repeated reports of references being made to Guantanamo, also to CIA torture and to impunity, as part of a recruitment narrative and as part of a discourse of them and us, that really undermines, I think, our shared humanity and international law. So I'll leave it there, but thank you very much for the opportunity. And perhaps, sorry, I won't leave it there. I'll say one thing because I'll get a row if I don't. This is terribly important. In terms of what we should do going forward, of course, I agree with the points that have been made about truth and accountability, but just to underscore global crimes that have been committed and violations by many states around the world, and all of those states, I think, need to contribute, yes, to the truth and to the accountability, to reckoning with the past, and also to bringing these violations to an end. And that includes, I think, with securing the release of people like Abu Zubaydah, offering to relocate those prisoners to other states around the world is a very concrete measure that states should be taking in our collective efforts to address some of this and bring it to an end. Thank you very much.
Thank you very much, Ellen, and I absolutely agree. I will try to be relatively brief for my intervention. I'm supposed to talk then on the spillover basic effect of this impunity. And I will arrogate 1 minute actually to follow up on one of the cases this year, rendition, because of course, when I worked on that, there was a case on my country, on Italy, where in 2003, an Egyptian cleric, of course, an imam, was kidnapped in the streets of Milan, ended up in Egypt. It was the subject of a rendition. I will not tell all the story of the rendition. It's actually in a case of the European Court of Human Rights. But what's interesting there is that it's the first case in which we managed to get to, the public prosecutor managed to get to a final judgment, also of the Court of Cassation and such of conviction, at least of the CIA agents, which was blocked. Basically, the accountability blocked, as Ellen was saying, because of secret of state, and couldn't actually influence any person physically because the Italian agents couldn't be prosecuted because of secret of state. And again, we see the same pattern. The reality is that the action of the law could go as far as accountability could be abstract. And as soon as it was possible to make it concrete with actual arrest or seizure of property, etc., the machine of secret of state, or even in that case of amnesties, came out properly. And still we are in that situation. And I think that it's a good bridge to what I'm going to say is that we talked up to now to the US-led program with the complicity of several countries, but the impunity of this program has actually brought a certain level of legitimation of other forms of renditions that partly pre-existed and partly actually developed after the program. There is an entire system in what is called the Commonwealth of Independent States, in the sense of the space of the former Soviet Union, if we want actually to define it as such, where the lead actor is, of course, the Russian Federation. This is a system which has been documented by many judgments of the European Court of Human Rights, and it is a system that actually lives almost on a compenetrated basis in the law enforcement counterterrorism work of these countries. So when we talk about extraordinary rendition, we talk about an intelligence program that was set up in this extraordinary paradigm of the war on terror. Actually, when we go and we studied, and the ICJ, we produced a report in 2017 called Transnational Injustices on this comparison. The situation in the Commonwealth of Independent States, we see actually that in those countries, that's the way counterterrorism is carried out. There is a convention, the Shanghai Cooperation Organization, in which Russia, China, and Central Asian states are members, that has typified 3 offenses: terrorism, extremism, and separatism. These are widely undefined offenses. In none of these countries exists a really strict criminal definition, but they are widely used in what in this country is called counterterrorism or security operations. Within these frameworks, basically, the whole plethora of extraditions, expulsions are used from one country to the other to actually transfer suspects of these offenses, which in reality oftentimes are from political opponents to religious groups or to human rights defenders as well. And we can see a pattern of practicality instead of rule of law. Law enforcement rationale primes over the protection of human rights of potential suspects. So we see really a pattern of the attempt to use legal processes like renditions. When those fail because of the rule of law, they resort to expulsions, immigration laws. When those fail because exactly there is a risk of torture when the person has been sent out, then suddenly we see that either intelligence services of the receiving countries are allowed the possibility to come and kidnap the person, or the intelligence services of the host country actually bring the person to the other country. I must say, in the last couple of years, it appears this practice has faded. I hope that's actually is actually also of the actions of courts and of the influence of the European Convention. But this is an endemic practice that basically has formalized systems probably of cooperations of the intelligence services in the former Soviet Union on the KGB, which used to be part of one service. But the discussion on and the impunity of the CIA rendition has provided the perfect dress of legitimacy to these practices, because every single time this was actually contested, the example of the US was brought there to say, well, look, at least we bring these people to a court, where, even if not independent, while the US system was actually only to keep for intelligence and not even for prosecution. So we see these activities, and we have seen also there are decisions of the working group on arbitrary detention on situations also in Turkey after the failed post-coup. Certain suspects have reportedly been taken from countries like Kosovo, Moldova, without following proper legal processes. And the problem is that under international law, we may say that there's not necessarily an obligation to go through an extradition treaty. But the practice we have seen, and I think also the report by the special rapporteur highlights, is that whenever formal processes are not followed, the experience is that human rights violations like arbitrary detention ensued, because that's natural. It's in the nature of things. When you transport a person from point A to point B, you need to deprive them of their liberty. If you don't have a formal process, you have already violated the principle of prescription by law. And what these programs do is taking the person away from the chance of having protection as a person before the law. I think Article 16 of the International Covenant on Civil and Political Rights is la clé de voûte, is really the pernus on which we see that this protection is taken away from the people and the rule of law is baffled. I will not take more time because we don't have much. I will, but I want to give this thread of legitimacy of what actually is the inheritance today of this rendition program. And I will give the floor to the UN Special Rapporteur, Fionnuala Ní Olin, for some closing remarks. I will note also that there is a question from Gaborone. I don't know if you want to address it in case Fionnuala. Is, do countries cooperating in the war of terror still hold detainees in secret and without access to judicial process? In the absence of accountability, have there been advances in state laws and practices designed to prohibit repetition? Fionnuala, the floor is all yours. And thank you.
Thank you all. And I just want to thank all the organizations who have come together to support this event today. Many of them have been really in the trenches for 20 years, have stuck with this issue consistently and not let it fade. And also to acknowledge that all of the people on this panel are also some of the people who've been in the trenches for 20 years, making sure that we do not forget and that we continue to hold states to their international law obligations in respect of extraordinary rendition and torture. I make remarks in the context of my forthcoming report, which will be presented to the Human Rights Council, and I think we'll share it in the chat in advance. Unedited edition is available for those listening who would like to see it. And that report really comes in the context of, as many on the call will be aware, in 2010, the Human Rights Council asked a number of special procedure mechanisms, my own included, to complete a joint study on global practices in relation to secret detention in the context of countering terrorism. And 4 mandate holders, myself, Special Rapporteur on Torture, Special Working Group on Arbitrary Detention, Working Group on Disappearances, brought forth this really quite extraordinary study, which really intended to pull together to bring a global picture of what was happening across all continents in the context of the use of extraordinary rendition and torture in the context of the war on terror. At the same time, a follow-up report was promised, and until today, no one quite had the bandwidth to do it, but with thanks to my team, that I should acknowledge all the hard work of those who work with me, we've been able to, I think, bring together this joint follow-up. And I do want to say a couple of things, that threads that really echo in the report that are follow from what the speakers have to say today. The first is the, I think, undulating role of civil society and other stakeholders in ensuring that this issue will not go away. There is no time limit on serious violations of international law. And those who have invested time and energy over the last 20 years in ensuring and seeking accountability and transparent, those voices are not going away. So much as states might wish that somehow this gets shunted off into a back room, I think the key point of this report that is issued next week is that actually it is simply not going away. And every single day we spend without accountability, where we have men still imprisoned, but also those men who were transferred out of prison, many of whom still live in legal limbos in multiple countries around the world, deprived of their most basic rights and entitlement. The claims for justice and accountability for those individuals and their families do not go away. The second thread I'd like to pick up on, because this is International Women's Day, and I note all of the extraordinary women, including Helen and Julia, who have, and my almost all female legal team who do all of this work in counterterrorism, is to say that this work of rendition and torture was profoundly gendered. It was gendered in terms of the male bodies who were the subject, the rarefied, raced male bodies who were the subject of these practices, but also gendered in terms of the impact of those practices on families, children, and communities around the world. And we tend to be focused on the men, as we should be, but for every man who was subject to this process, or boy, because boys too were rendered across borders and tortured, there were families who literally in the last 20 years have not seen their family member, have had the most intimate and precious of family and human life taken away from them by virtue of nameless, faceless processes that have held themselves as unaccountable to international law and domestic law. And the third line I would like to take from the conversation today is the focus on serious crimes under international law. The 2010 joint report identified a nascent understanding at that point that these kinds of crimes would be implicated. And I think the report that's been issued by my mandate really focuses on the implications for serious violations of international law, and the lack of a statute of limitations. As Bob has said, if we're talking about crimes against humanity, there is no statute of limitations, and states should really understand and internalize the consequence of that. Fourthly, I want to focus on as Massimo and Julia have both addressed, the export quality of these practices. So it is, I think, important to say that we have had, including through the work of ICJ on transfers, Amnesty's work and others, Human Rights Watch, Open Society, and many national level organizations, even a small little truth commission in North Carolina that took the time to figure out what was happening in their own backyard. All of those have illustrated the way in which actually there was an export quality at the time in terms of the scale of states involved. But what I think I would also underscore is the export quality of what's happening today as a result of the lack of accountability. And the report that I will issue next week looks particularly at two other sites that are particularly important: Xinjiang, China, and Northeast Syria, where large, massive detention practices continue because, in a sense, the permissibility of rendition post 9/11 has enabled an environment in which states think that can be done without consequence. I also want to underscore the point that it is mine and the Special Rapporteur on Torture's view that the ongoing experience of the individuals held in Guantanamo Bay, Cuba, constitutes torture, inhuman and degrading treatment under international law. This is not a past experience, as Helen has said. This is a present experience lived daily by those individuals who continue to be subject to a regime of arbitrary detention and who live with the daily consequences of torture wreaked on increasingly aging bodies for whom there has been inadequate medical treatment provided over at least 2 decades. Let me close by saying that one of the most important things I think that I will do next week is acknowledge the names of all of those individuals who have been subject to this practice. So there's a great tendency to sort of invisibilize those who have experienced these harms. And one of the things the follow-up report does is provide an annex of names. And really, I think the kind of humanity of reclaiming people's names in the context of their most basic rights being taken away from them is enormously important and significant. And in addition to that, the obvious point is that not a single one of those individuals has had an adequate remedy. And that, in today's day and age, is simply unacceptable. So let me close and thank again all of the speakers and all of the organizations who continue to have this conversation and who seek to find a resolution for the ongoing challenges of extraordinary rendition and torture. Thank you.
Thank you very much, Fionnuala. I'm going to apologize a bit with everyone, all the panelists and the followers of this event, because we will have to close in 2 minutes, so I will not have the possibility to give the floor for question and answers, exactly because of the UN Human Rights Council. In 5 minutes we have other informal negotiations, so I will need to leave, and I'm the host, so this room cannot stay open without me, unfortunately. This is the problem of technology. I want to thank you really profoundly, all the speakers, ICJ President, Professor Robert Goldman, Julia Hall from Amnesty International, and Daphne from Rights in Practice, and the Special Rapporteur Fionnuala Ni-Olin. I feel privileged kind of to be a student. I started really my career with renditions, and yeah, it is sad after 20 years that we are still here talking, but I feel very inspired when I hear you all showing very clearly the determination that these crimes under international law must be prosecuted and that the work will continue, because this is important not only for accountability for these victims, this is important for the right to truth that we need as society overall, we all need to reckon with these crimes so to avoid the repetitions in our countries. And I think it's really important, all the work you're doing, and I hope we will all continue to do so. Thank you very much to everyone. Thank you very much to the people following, and never give up. We will continue, we will prevail with the